to dive into the intricate world of taxation in East Africa. My name is Brenna Ishimwe. I serve at the Secretariat of East Africa Law Society as a communications officer. We have a panel of experts today lined up to share their expertise, insights on how to stand out, or in other words, how to stay ahead of the game in this field of expert. Thank you all for making the time. Thank you for choosing to be part of this conversation today. Let's dive into it. Apart from our panelists, we have two special people today with us who are going to facilitate our discussion on the new era of taxation. Allow me to introduce them. I start with our moderator today is Mr. Ikoha Muhindi. He is an advocate of the High Court of Kenya and a principal associate with the ALN Kenya. He works under the Dispute Resolution Department at the ALN Kenya office based in Nairobi. He advises and represents clients in a wide array of civil and commercial disputes. Our co-moderator today is Ms. Lilian Muikali, who is an advocate of the High Court of Kenya and a partner at RMY Advocates, and she heads the commercial department at RMY Advocates. So, Mr. Muhindi, the floor is yours.
Thank you very much, Brenna, for that introduction. And once again, I'd like to extend a warm welcome to all of you participants to this webinar, where we'll delve into a very interesting topic on the trends across the region. As we all know, the East African region is a very key region within the continent and has a lot of potential in terms of how we'll proceed in the next coming years. And undoubtedly, this past decade has seen quite a lot of changes in the trends in the region, commencing with the initiatives by partner states within the community to put in measures to cushion the citizenry from the harmful or negative financial and economic effects of the pandemic. And those initiatives have slowly morphed over the last 1 or 2 years, where now we are seeing the partner states are now taking steps to align their tax policies and tax initiatives in line with global standards. So this afternoon, we have 4 panelists that will be speaking to us about these trends. And in terms of how we'll proceed, we will take one panelist at a time. And without further ado, we will start with Mr. Eli Obegi from Nairobi. And Mr. Obegi is a dispute resolution and tax lawyer currently working as a senior associate at Oraro & Company Advocates. Mr. Obegi has accumulated approximately 6 years experience as a legal and tax professional, where he specializes in complex tax and commercial disputes before the tax appeals tribunals, the High Court, and also regional courts in the region. Eli has also advised on a number of tax and commercial transactions that both at his current role as a senior associate, as well as his previous roles as a senior associate at PricewaterhouseCoopers, Nairobi. Additionally, Eli is an advocate of the High Court of Kenya, as well as an associate member of the Chartered Institute of Arbitrators. Without further ado, we'd like to pass the floor to you, Eli, and perhaps you can let us know some of the interesting trends that have emerged in Kenya in the recent years. And in doing so, please also share with us maybe 1 or 2 key decisions that have impacted how businesses operating under the tax regime in Kenya.
Thank you very much, Ikoha. It's a pleasure to join all of you as our colleagues from East Africa for this session. Just if you give me a second, I'm attempting to project some slides. Just to confirm, you are able to see the presentations?
Yes, we can.
We can see the presentation.
Yes.
Okay, thank you very much. This afternoon, I'm joined by my colleague, Liana Guto, who is next to me, who is also a lawyer here at Oraro & Company Advocates. She will be assisting me as I go along with the presentation. So I'd just briefly like to touch on one or two areas which have arisen over the past couple of years concerning taxation in Kenya. This is just a brief outline of what I intend to look at. We'll talk about briefly taxpayer participation in taxation, and more specifically, taxpayer participation in lawmaking and in the passage of the annual budgets in Kenya and the amendment of tax laws through various finance bills and acts. I'll also talk about some developments specifically that have arisen in the Finance Bill of 2024, which was published this month and is undergoing the parliamentary process in Kenya. Here I'll speak about taxing the digital economy and the 2 or 3 taxes that Kenya is grappling with when it comes to taxing specifically digital services. I'll also talk about some taxes that touch on the environment and environmental matters. There's been an interesting proposal to introduce motor vehicle tax as a wealth tax in Kenya, as well as the minimum top-up tax that is proposed to be introduced. I'll also be talking about data privacy and taxation, as well as 1 or 2 issues in the tax dispute resolution process. So just to kick off on taxpayer participation in Kenya, and I believe this is not just a Kenya-specific issue. I'm sure my colleagues from across East Africa will bear me out when I say that there has hardly been sufficient public participation by taxpayers whenever our budgets are being made, whenever proposals are being made for inclusion in finance bills, and whenever amendments to tax laws are being undertaken. This is despite, for example, in Kenya having a very specific, clear constitutional provisions on public participation and the role of the involvement of what we call Mwananchi or Wanjiku, that is the common man in the course of lawmaking, and specifically in financial matters and tax matters. As we can see, public participation is a national value and principle of governance in Kenya under the Constitution. The Constitution mandates Parliament to facilitate public participation and involvement. And specifically Article 201, which is the key provision in the Kenyan Constitution on taxation and public finance, states that there should be openness, accountability, and public participation in finance matters. It's also a principle of public service to provide for transparency and timely and accurate information. However, in practice, we haven't really seen that participation we haven't seen the public being involved and participating to the desired standard. That is not to say that there is no participation. There is quite a bit of participation. In particular, the lawmaking process and the budget cycle in each financial year is really great at allowing Kenyans, interest groups, NGOs, lobbyists, business people to give their proposal for the kinds of tax changes that should be seen in the annual cycles. So each year starting around November, the government usually collects policy views on the budget as well as on the proposals for tax changes. So Kenyans are able to give their input on what kind of changes they would like to see in the various taxes. Once the bills are published, like what has happened right now, the bill is out for public participation, it's published, and Parliament is accepting contributions from Kenyans. It's a process that should be ongoing through submission of written memorandum up to, I believe, 28th of this month. Thereafter, there will be public hearings and people will give their view. The challenge, though, has been on the part of proposals made by the government, as opposed to proposals being proposed by Mwananchi. On the part of proposals made by the government, we hardly ever get wind of what changes are proposed until a finance bill is published, as was the case recently. So unlike in the case of proposals being made by the private sector and other members of the public, which have been set out and discussed all the way from November to date, these ones just come sometimes out of the blue. You will find changes that are not backed by policy document. Perhaps there's no white paper setting out the rationale for the tax. And in the absence of such, it could be said that members of the public are not able to properly interrogate and deal with the proposals in the absence of an understanding of the policy aims that the government is trying to achieve, the alternative proposals that may have been considered before such a proposal was arrived at as the best possible case for proposal for enactment. So these are some nuances around taxpayer participation within the tax framework in Kenya that are important. And time again, you find the issue of, was there adequate public participation? Was there adequate taxpayer participation? It will always arise from time to time. We have an example before you of the Finance Act of 2023, which as soon as it was passed was challenged, in that case of National Assembly versus Okoiti Omtata and others. These were, Leon, I believe, 11 consolidated petitions challenging the Finance Act of 2023. And one key challenge raised by almost all the petitioners was whether there was adequate public participation before the enactment of the law. One key issue that they raised was, what happens when we have been discussing certain proposals from November up to the publication of the bill. The bill is published. We give our comments on it. Our comments are incorporated into a revised bill that is then taken to the floor of the House, and then suddenly we get a number of new changes and sometimes new taxes introduced that nobody has discussed before. Can we say there was adequate public participation on those? The jury is out. This case was determined by the High Court, which declared some of the provisions of the 2023 Finance Act unconstitutional. But it's under appeal at the Court of Appeal, and we are really waiting to see what the Court of Appeal is going to hold. I can flag, a key issue around which there was a lot of controversy, which was the housing levy, as it was then enacted under the Finance Act of 2023. So this was found to be unconstitutional because the amendment did not have a proper legal framework. It was done through a simple amendment to the Employment Act, stating that employees shall be charged a levy, but without an enacting framework, a law setting out which authority shall govern the funds collected under the levy, setting out, establishing a fund into which those levies are going to be paid in, and setting out the collection mechanisms, etc. So this was a reason why, one of the reasons it was declared unconstitutional. The other was because it was argued to be discriminatory. It was a tax targeted specifically at employees, but other people who are not employees, people who are, self-employed, and other people in business were not required to pay the tax, hence the discriminatory nature coming out. And as well, because it was an amendment to the Employment Act, it was not an appropriate amendment to be passed through the Finance Act of Bill, which is a money bill that requires to deal with matters of government revenue and not other acts such as the Employment Act, etc. Moving away from this, I will briefly talk about a few developments that have been proposed for the 2024 Finance Bill. A key issue surrounds taxing the digital economy. This has been a bone of contention, and it's something that the Kenya Revenue Authority has been grappling with over the last 5 or so years. This really is stemming from the fact that increasingly the economy of Kenya and our economies in East Africa and Africa are more and more dominated by the service industry as opposed to the manufacturing industry and trading in goods. So increasingly services are taking up a big chunk of the economy. But the challenge that arises with the taxation of services is specifically the manner in which service providers are not geographically restricted. It is possible for anyone to provide a service to almost anyone else without the need to sit geographically in Kenya, have a physical base of operations in Kenya, have a company registered in Kenya. So this brings a challenge of how do we tax all of these entities that are providing services, are certainly earning income and making money from Kenya, but are not physically here. It's not very easy to audit them. They are not registered here. So what do we do with this? Sometime in 2020, the government of Kenya had introduced a digital service tax, which was basically a tax at the rate of 1.5% of gross transaction value for certain services that had been defined to be digital services. These were defined as any services that are provided through a digital platform or a digital marketplace. There is a proposal now to slightly tweak. It is touted as a replacement of the digital service tax with a new significant economic presence tax, although in practice, the tax will largely operate the same way as the digital service tax operated. It is still being taxed on revenue, although it has now come up to 6% as opposed to 1.5%. It's 1.6% of any transactions that are again undertaken by persons who are deemed to be undertaking digital services. The definition for those digital services has slightly been changed. It is still services undertaken through digital marketplaces or platforms, but it has gone a step further to provide a little bit more clarity. For example, digital taxi hailing services such as Uber, Bolt, etc., are now specifically caught up in the definition. Things such as Airbnb and any other platforms providing for hotel room stay services through a platform will also be caught up in the new act. There has also been an introduction that came in through the Finance Act of last year of a withholding tax on digital content creators. This is again another aspect of the digital economy that requires to be caught up in the tax net so that we can increase the tax base in Kenya. So this was proposed through a withholding tax that will apply whenever any payment is being made to a digital content creator. This is still proposed to be somewhat tweaked in the current 2024 financial cycle. The rate is 5% for resident persons, 20% for non-resident persons, and it will apply on any payments in respect of digital content monetization that is accrued or derived from Kenya. There has been a change to clarify that that withholding tax is a final tax, so that non-residents do not have to, go ahead and make any further filings after this withholding tax has been imposed. Moving away from aspects of taxing the digital economy, we briefly speak about the introduction of a minimum top-up tax in Kenya. This is really part of our efforts to implement the OECD Pillar 2 framework, which is aimed at ensuring that large multinationals that operate in multiple jurisdictions actually do pay their fair share of taxes in each of the jurisdictions in which they operate. This is to ensure that they do not take advantage of low-taxed jurisdictions to evade or avoid paying their fair share of taxes. How it operates is that it's intended to ensure that there is a minimum effective tax rate of 15% on the large multinationals that are caught up in the minimum top-up tax. The entities that are caught up are entities which have groups which have revenue in excess of 750 million euros. So it's quite a high threshold, but any groups which are caught up will have to pay an additional tax in Kenya to bring up the effective tax rate in Kenya to 15% to ensure that there is at least a fair share of taxes being paid in every jurisdiction, and again to ensure that Kenya itself is taking up the jurisdiction to tax and get a benefit out of the tax out of taxing the income earned by these entities. I'll briefly let Lian speak about aspects of environmental taxes and the new motor vehicle tax.
Okay. So with regard to environmental taxes, in Kenya, there have been several strides towards ensuring that we comply with international best practice, international standards of environmental conservation. For example, in 2023, there was the introduction of an amendment to the Climate Change Act to introduce carbon credits to deal with offsetting carbon emissions. So this is one of those moves. So the eco levy has been introduced and will apply to specific goods such as computers, rubber tires, cameras, projectors, even diapers. And they are identified by tariff codes to specify what amount will be paid for each one. It basically goes in line with the polluter pays principle in the sense that where products that are produced are likely to cause harm to the environment, the polluter is meant to pay for such harm. And this basically will help the government to fulfill its international environmental commitments, and it's expected to increase tax revenue. Like most things, there are mixed reactions to the introduction of this tax, because there is the argument from the Kenya Association of Manufacturers where they say that it will increase the price of basic commodities which are packaged in plastic. So that will generally have an effect on the taxpayer as well. And for this reason, there needs to be a balance that is struck between the taxes that are to be paid and with the polluter pays principle. Other taxes that have been introduced that are in line with the environment and its conservation, there's excise duty that has been imposed on certain products that would be harmful to the environment. For example, coal was previously had no excise duty that was charged on it, but now there's a 5% of the value, or 27,000 shillings per metric ton, whichever is higher. There's also a 10% excise duty on certain imported articles of plastic. These are all in line with ensuring that the polluter pays for the harm that they cause to the environment. I think I can move to the next one, which is the introduction of the motor vehicle tax. Now, this one has been a problematic one since the publication of the Finance Bill 2024, and has been something that has been spoken over by members of the public, by the Association of Kenyan Insurers. And basically, the motor vehicle tax will be charged at a rate of 2.5% of the value of the vehicle. Now, the value of the vehicle will be ascertained based on the size of the engine, based on the general value of the vehicle. And there are exceptions to this tax, to this proposed tax. And this include ambulances, government-owned vehicles, or vehicles owned by people who are exempt from tax under the Privileges and Immunities Act. Now, arguably, the motor vehicle tax is not an income tax. With reference to the Court of Appeals decision in Kenya Revenue Authority versus Waweru and 3 others, income taxes should be applicable on income and not on any other basis. So this is not a tax that's applicable on income. It's not a tax that's applicable on profit. It's a tax that is just charged by virtue of a person owning a vehicle. Now, according to the Kenya Association of Insurers, this proposal is likely to impact taxpayers, to impact the general public in the sense that many people will avoid getting comprehensive car insurance cover. And as a result, there will be less income generated by insurance companies. For that reason, it could lead to job losses, which will in the end have impact on the general public who are employed in such institutions. I think that's all. We'll move to the next one.
Yeah, so just to briefly talk about another very interesting area that has caused a bit of controversy, which is issues surrounding data privacy and data protection and taxation. The provision that has brought in, a bit of controversy is what is on the screen right now. There's a proposal to amend the Tax Procedures Act and the Data Protection Act to exempt any processing of data which is necessary for assessment, enforcement, and collection of tax under written law from the provisions of the Data Protection Act. So the concern here really is that the Kenya Revenue Authority is being given unfettered access to personal data of Kenyans without any of the safeguards provided for in the Data Protection Act applying to such access to data. And, this brings concerns of, surveillance of Kenyans by the Kenya Revenue Authority by applying these sweeping powers that it's being given. The concern on unnecessary disclosure of information. There are some concerns about data security itself. Has the Kenya Revenue Authority and other related government bodies in the tax administration process, do they have sufficient data security safeguards? Are we sure that this data will not end up in the wrong hands? Have they been subjected to, audits of their capabilities to actually maintain the security of the data that they are proposing to give themselves wide powers to access? Although an interesting comment to note here is that while it may appear that it is this amendment that is giving KRA these sweeping powers that have been the subject of controversy, it's actually arguable that the Revenue Authority has always had these powers. If you look at its powers to demand any kind of information from any person under the existing provisions of the Tax Procedures Act, it has very wide powers. They can ask for, almost any and every piece of information from a taxpayer, from people who are doing business with the taxpayer, and it's a criminal offense to fail to comply with such requests for information or documents. So arguably, the Revenue Authority does already have those powers. They may not have been very keen to enforce them, and that is something that we should be on the lookout for, to see whether with the passage of this provision, there will be increased enforcement actions and them increasingly using these powers, and particularly that threat of criminal prosecution should you fail to cooperate as they go about their business of enforcing tax laws. Just finally, speaking of case law coming out of Kenya, there have been some developments that are in favor of taxpayers. People like Ikoha and others among us who deal with the tax dispute resolution process in Kenya, I'm sure have suffered a lot of problems with attempting to respond to certain assessments or decisions made by the Revenue Authority in circumstances where the Revenue Authority does not provide reasons for their decisions. So you find yourself as a taxpayer with an assessment and a demand to pay, 10 million Kenya shillings, but you do not have enough documentation to find out how this sum was arrived at, what it relates to. So you have quite a bit of a challenge in responding to the kind of assessments that are given. Yes, you have the right to appeal to the Tax Appeals Tribunal, but without knowing what the genesis of the tax is, it is very difficult to mount a successful appeal that will challenge this. But there have been a couple of decisions from the Tax Appeals Tribunal and the High Court in the recent past. We've just highlighted one of them here, where the High Court has really come down hard on this practice of not giving taxpayers adequate reasons. Where the High Court is reiterating that the duty to give reasons is not a trifling requirement, and reiterating that being a constitutional mandate, which accompanies the right to fair administrative action under the Kenyan Constitution, the KRA and other players in the tax administrative process have no choice but to give reasons for actions by taxpayers. In this case, it was a very interesting case. It was a VAT assessment where the assessment came in without reasons. The Tax Appeals Tribunal actually set aside the assessment, and the High Court on appeal confirmed and set aside the assessment purely for the failure to give reasons. So these are the kinds of decisions that we have been finding that, are at least protecting taxpayers' rights and affirming, the taxpayers' right to actually challenge an assessment from the Revenue Authority and obtain justice. I think we'll stop there, and I'll hand over back to Ikoha, who can invite the next panelist.
Thank you, Obegi, for sharing your wealth of knowledge on this subject. Just to the members, you can key in your questions on the chat box. We'll have the panelists answer your questions. So moving forward, I'll invite our next panelist, who is Chacha Mairo, who is a partner at Law Hill and is one of the Tanzanian leading tax and corporate law firms. He has over 5 years experience in advising entities on tax compliance, tax considerations, in choice of corporate forms, transactions and entities, structuring, tax planning, tax and legal health checks, and also tax due diligence. Besides his legal practice, Chacha is an academia and has done research, delivered tax lectures and undergraduate and postgraduate students on complex aspects on tax. He is currently researching and working on carbon taxation as an emerging area on the use of taxation in addressing global climate change impacts. So I will allow Mr. Chacha to share his thoughts on our topic today. Mr. Chacha, you can take over.
Well, thank you, Lillian and colleagues. Happy to join here. So apologies, actually, unconventionally, I won't be able to use my video in the country, and I have some limited challenges. Well, so I'll go straight. So I'll be discussing on emerging trends of taxation in Tanzania. And of course, we'll look at very few judicial pronouncements which have affected the Tanzanian tax landscape. So to begin with, Tanzania is a union between Tanganyika and Zanzibar. So the tax structure is also different. We have union taxes and we have non-union taxes. So income tax, import duty, which is custom duty. So those constitutes major union taxes. And of course, each jurisdiction also have its own, administers its own taxes. So VAT, stamp duty and excise duty, among others, together with some levies. Those are actually non-union taxes, as you can see. So that's the structure, and actually this structure often affect each of the tax base, the unit. So who bears the liability. The amount also is different. Example, in VAT, Tanzania mainland is 18%, Zanzibar is 15%, but also each of the tax administration procedures. Now, so in line with also the colleagues' presentation in Kenya, we are not in an island. Recently, I've singled out these main 6 issues that are cropping up here in this jurisdiction. So we have digital service taxes. We have, of course, environmental taxes, quite actually developing. Of course, with the current regime, we also have, we use the taxes to incentivize, to welcome investments and mega projects which are ongoing. We have a creeping administration issue on use of ADR in resolution of tax disputes. We had the notorious levy, but also we have quickly some of the key administration developments recently, and particularly actually aligning with all these issues. Now, to begin with the first one, digital service taxes, the colleagues from Kenya have pointed out, I think theirs came in quickly, rather earlier. So we understand the developments at the global, currently actually the BEPS, the base erosion and profit shifting, actually the global minimum tax rules, and which have also, which were informed much of the shift of traditional model, from traditional model to digital supply of services and goods, such that now we have the digital marketplace where people are transacting. So the government here took early initiatives, enacted certain statutes enabling legislations in each of Cyber, Electronic Transactions Act, e-government, and many, which actually welcome that development on e-commerce and actual technology. In the context of taxation, in 2022, the Finance Act introduced digital service taxes, but also they extended the VAT liabilities to suppliers who are non-residents. So actually, specific regulations were enacted to target these non-resident electronic service providers or suppliers. And subsequently, all these developments in 2022, and of course the amendment, currently provide for what constitutes electronic service, which is the base, quietly defined, those done electronically or over the internet. It also recognized that shift from traditional to digital marketplaces where now transactions can be conducted in actually VAT and each of income tax imposed. The regulations and actually the law provides currently for these non-residents in particular requirement to register with the tax authorities. And ultimately, of course, they would have to pay digital service tax of 2% of the gross turnover, while VAT actually remains, which is 18% the rate. So you would see this development is coming in. The target initially were for these fintech and actually these tech companies in each of WhatsApp, Google, and all the likes. But currently, actually, previous month, the government said it has been able to collect around, TZS 300 billion out of all this registration and compliance. But you see our rate is quite is 2, the Kenyan is 1.5. But of course, the only difference here is that we have not yet implemented the global minimum tax rules. So we yet actually would depend on whether the multinational is operating in another jurisdiction actually to suffer that one. We also still have challenges in this in implementing these digital service taxes, as you see. So we understand our tax administrations are still running behind time. So in each of personnel, in each of systems, because taxing electronic and actual transactions in the internet requires a very robust, a very techy administration. So we have that one as a major challenge at the moment, but also we have very limited application of those rules to residents, unlike the Kenyan, which is actually very, very developed, as the colleagues have presented. But yet, actually, the changes are ongoing, and hope that the future of this part will be very exciting, and perhaps would let us see how the rules will be applied and actually developed in wake of what is ongoing in the global space. Then second, so we understand also we had regime changes, okay, from 2021, where new government assumed the constitutional position actually as it could be. So there has been a move to welcome investments, and actually currently we have a number of legislation, a number of developments, amendments which actually key in this. It's quite that move. So since 2021, the Finance Act, we have the New Investment Act of 2022. We had also specific legislation, Latent Laws Miscellaneous Amendment Act, only for financial provisions, and actually ongoing Finance Act, which provides for this. All these, and actually the effect of all these developments currently is to increase incentives on import duty exemption on deemed capital goods. We also have VAT deferment on capital goods for each of investors bringing in capital equipment. You understand, in each of these investments that Tanzania is actually running, and mega projects which we are aware. So we have the standard gauge, we have the electronic hydropower plant, we have LNG, we have ECOP with the colleagues from Uganda. So all these have been factored in, and actually taxes have been used as the best way, together with other non-tax incentives, actually to welcome this in. We have a number of, the Minister now of Finance has also is global enormous powers to grant these VAT and income tax exemptions on strategic investments, mega projects actually. We have excess duty remissions and the normal ways in which investments are welcomed. And of interest, actually, we know currently from 2022, corporate bonds are exempt from tax, from withholding tax, and ultimately for the past 2 or so years, we have had many companies who have listed the bonds, have issued capital mobilized, have listed here, and of recent, actually, we had a very top commercial bank here, close listing actually its bond in London Stock Exchange. So quite that one also. We also have to provide, we understand climate change is currently a very, very serious thing in each of everything, in each of all of our decisions that we are taking, in each of our consumption of each of any good and service. We factor in from a bus ticket to a motorbike, to an when you catch a flight, to the water you drink. So all these issues are currently, we have to consider the production, the supply chain, and each and everything. So we would say the summary, as you see, we are not yet, we not yet robustly implement very serious taxes. So we rely much more on environmental regulation, prohibitions, more on environmental legislation. But yet also, we have developed recently to consider certain use of taxes to actually address this sustainability in wake of also achieving the sustainable development. So you have more from 2022 and 2023, a number of issues coming in. Currently, we have excise duty on motor vehicles. It came in Finance Act 2023 from the CC, so the engine capacity, 1,000 to 2,000 cc engine capacity, then it's 5%. Over 2,000 cc or engine capacity is 10% actually out of the dutiable value, which is the motor vehicle value assessed. Then, so this is on engine. Then we have excess duty on old age vehicle as part of an anti-dumping policy, actually to encourage people to buy vehicles which are quite new, but also because we know the old vehicles also pollute more. So this is the discouragement mechanism. So we have a very significant excess duty of 30% for old age vehicles of 10 years or more. And actually for less than that, but 8 years to 10, 15%. And actually the rate is different for buses and tractors. As you have seen actually in the slides, the screen shared. Last year, we also put in certain developments in terms of cars that use gas and electricity. We understand these are clean, the clean energies, unlike actually fossil fuel. So there is a certain leeway for this lesser. And we have also VAT exemptions for conversion, actually, for those automobiles which are used to convert the fuel system from the normal fossil fuel to natural gas and electricity. An interesting thing is the Finance Act 2023 is now what came in as withholding tax in respect of payments from verified carbon emission reduction. So we call them CERS. So this provision initially, so we understand cells actually from clean-based development mechanisms. So those planting of forests using climate-friendly technologies, out of which would earn those carbon credits. So many people have developed the projects, forest projects, mostly here in Tanzania, and they do sell those projects to multinationals, but also to countries who need these credits to achieve, who have exceeded their limits, their assigned amount in the Kyoto Protocol. So when they sell these amounts, when they sell these units, there is a fair share of revenue. Okay, a portion goes to the ministry, a portion goes to the developer, a portion so this way. So now that resident person who receives income out of these selling these credits is now supposed to pay 10%, as of course payable in form of withholding. Now, so I'm calling this a dragging back provision because you understand if it's sustainability, so we have to welcome and actually to incentivize people to develop these projects. So one of the incentive would be to remove the tax component when a person sells the units, but the government has actually imposed taxes for those project developers and actually those who would sell the credits of 10%. So I'm not sure, as I've posed the question, is it revenue generation or sustainability? What are we trying to achieve? But yet actually the discussions are ongoing on whether, on actually how best we can try to catch up with this. We are yet to put in carbon tax. We don't have an eco levy, as you see. So we have a couple of regulatory mechanisms. Less of them are taxes. Few of them, which you see, are excess duty. And of course, lamenting while in dragging back withholding tax if you sell carbon credits or rather sales. That is actually in the context of sustainability, which is very interesting. Then the colleagues from Kenya started with the housing levy, which is tricky currently. So we are still passing through what we're informed that it is development levy. We have to contribute, we have to contribute to development of the country by actually paying a certain amount of money from the transactions which we perform by sending money, but also by withdrawing or by purchasing airtimes using our mobile devices, or rather if using electronic means. So in 2021, the Finance Act introduced this requirement, amended the National Payment Systems Act, but also the Electronic and Postal Communications Act, introduced this levy, named actually for purposes of development. Now, so it led to Tamil's public outcry, and then this levy was actually, the base was reduced, the amount was reduced, and then later, so the levy was removed from only from transferring to now withdraw. But it's yet there, and people are questioning. A lot of issues actually, Tamils, if it's actually publicly accepted as the house. So this would be the sister of the house levy in Kenya and the Tamils, which is ongoing. And so this is the sister and actually impacting the general public and every one of them of the 45 million Tanzanian who is using a line. If you don't transfer, then you will withdraw, or rather you use in your airtime. Then in the context now of dispute resolution, in the context of dispute resolution, we have for years been hesitant to adopt ADR in resolution of tax disputes on quite a range of policy issues, which you guys and all the colleagues here in each of the partner states appreciates, or rather do not appreciate. But in 2021, the government introduced, allowed now taxpayers at any point in time before the dispute, before judgment, parties may settle the dispute. By that provision in 2021 was through mediation. Okay, then in 2022, the government thought that, and actually, which it would be, that provision was very narrow. So instead, it amended that it amended from mediation to amicable settlement. Okay. Currently, the position is that at any time before judgment, parties to the dispute, taxpayer and the revenue authority may settle. Okay. We understand what this saves. It saves time, it saves cost, ensures revenue is collected timely, but yet the challenge remains. The challenge that remains is that currently the Tanzanian ADR in resolution of tax dispute do not provide a clear. There is no actually clear and elaborate framework. Okay, I'm intrigued, or rather, I'm interested. The Kenyan approach is simple, or rather, is straightforward. There are clear guidelines which provide for how actually mediation or arbitration or sort of each of the ADR will be conducted, but also the timelines. So the Tanzanian approach, we do not have specific timelines in which the mediation or negotiation, actually currently it's negotiation, is conducted. When would it be conducted? What should you file? So we have a practice, and what will be demanded, what is required. So currently they would say if it's a point of law, we cannot settle. If you want to, you have to write a letter. Then we would sit as a panel, we'll discuss. So the issue is, what if parties want to resolve through arbitration, example, which is an ADR mechanism, or mediation, where they want a third party to come in. So the rules, or rather the regulation, do not provide to that effect, especially when you want a third party to come in. The Kenyan says you can appoint a mediator or an arbitrator, and actually what will be the effect of that decision, the Tanzanian, and actually the timelines within which, if it fails, you have to go back to court. Hours you can go on and on and on and on until such time the court says no, now we have to proceed if you do not settle. So that's actually quite positive for fast forwarding, but actually getting back in those issues. Then as I've said, so in the context of administration, we experiencing currently change which influences the future of taxation here. Most of the practitioners and us actually appreciates, given the change of regime. So currently the tax administration bolsters itself to actually have increased revenue collection because it uses proper ways. Initially, there was the use of tax forces, the use of law enforcement agencies to collect taxes which is due, the use of urgence notices, levying money from commercial banks in the accounts of taxpayers without due process, and a number of issues, and a number of many issues which are public. But currently, we have these developments. In 2022, we also have an ombudsman office where taxpayers who are grieved by normal administration issues may channel the issues. But yet the question remains, is it old wine in the new bottle, or is it new wine in the old bottle? Because there are also yet creeping issues which affect significantly taxpayers. Now, so those key five, I thought they're of interest, but also I'm actually enjoying to share with you developments, judicial developments, at least two. So I'll just pick two here, and perhaps if I have time, I'll see here I just have to wind up. Well, so we have two decisions. These decisions are legacy decisions, and actually they came in from 2015 to 2021, and they affect and would keep on affecting the tax landscape here. So we have deductibility of bad debts and impairment provisions to financial institutions. These cases, the Court of Appeal, they usually have said that if for a taxpayer to deduct bad debts, he has to exhibit reasonable steps. And reasonable steps are not stated, they are not defined. So at all time, financial institutions have found themselves not able to deduct. And then the second, I'll just pick two. There are many here I was just singling out, but the second one is this one. This is a very important one. Actually, incidence of withholding tax, this one, the Commissioner General, which is VTPLC. So this decision is to the effect that withholding tax is payable when payment is made and not when the obligation accrues. So the current appeal is pending before the Court of Appeal. Recently, the Tanzania Revenue Authority would demand, because you account expenses on accrual, so they would demand also that withholding tax be paid when the obligation comes, even if you have not actually paid. So the appeal is pending before the Court of Appeal. It's a very interesting decision because it affects a number of tax landscape. The other components actually you would see, so the matters, actually the slides will be shared to you. You see these cases and developments in each of the administration and issues. But from Tanzania, so I say thank you very much. That was very of a marathon. You see a Concorde, so actually landing here, and hope to have an engaging discussion with you. And I will have to pass it to the colleagues, Lillian or Kel, now to proceed. Thank you very much.
Thank you very much, Chacha, for that insightful presentation. Now, moving forward, we'll move to our next presenter, that is Sophia Nampija, who is a Principal Associate at Katende Sempebwa Advocates in Uganda. Sophia has over 13 years experience in corporate and commercial law advisory, with a specialty in structuring, negotiating, and executing high-value transactions in Uganda within the oil and gas, renewable, telecommunications, infrastructure, and project sectors, to mention a few. Sophia also has a vast experience in structuring investments and financing, business establishment and licensing, regulatory compliance, and preparation, review, negotiation, and execution of complex project documentation. She's also a member of the New York Bar and a holder of a Master of Laws from the prestigious University of Houston in the United States. Finally, Sophia holds a postgraduate diploma in revenue and taxation from the East African School of Taxation, as well as a postgraduate diploma from the Uganda Law and Development Center. So we welcome you, Sophia, to the chat, and we'd like to get a bit of an insight on the new era of taxation within the Uganda landscape. Welcome, Sophia.
Thank you, Ikoha, for that introduction. It's a pleasure to have the opportunity to present to the members of the East African Law Society. I have commenced screen sharing. I just wanted to confirm if, Ikoha, if you can view the presentation on your end.
Yes, we can see the presentation.
Thank you. So I'll dive right in. My presentation covers 3 areas. Very quickly, the budget highlights, proposed amendments to our tax laws, and recent tax decisions and implications on the tax landscape in Uganda. So I'll not delve a lot on this, but the reason I mentioned mentioning our budget for Uganda financial year 2024-2025 is because it's likely to have an impact on enforcement measures and enforcement measures and the manner in which URA, who is our tax regulator, will react towards our clients. Initially, the budget was 58 million, I think, when it was presented on 28th March. And normally the budget is presented alongside the proposed amendments. So, but I think less than 2 months later, on the date that we expected the budget to be passed and the laws to be passed as well, the budget was increased by 20%. And out of that, I think nearly half, 32 trillion, is expected to be sourced from domestic revenue. So this is the most important point on this slide. If this money is expected to be sourced locally, then what impact is that going to have on the tax measures and enforcement measures used by URA? So the tax proposals that, the tax bills that were presented to Parliament and subsequently passed are 5. There are changes to the Stamp Duty Act, Value Added Tax Act, Income Tax Act, Excise Duty, and the Tax Procedures Code Act. All these, if assented to by the President, will take effect on 1st July 2024. The changes in the Stamp Duty Act and Value Added Tax are very light, but I just wanted to touch on a few in the Income Tax Act and Excise Duty, as these are the ones that presented or were received, are the ones that were reacted to more, what should I call it, had a bigger reaction from the taxpayers or the tax community. So income tax, we have exemptions. I think they are fourfold. What was interesting, so initially there's certain proposals that I think were made when the taxes first came out. The one that solicited the biggest reaction was the proposal to slap a tax of about 5% on non-business assets. So basically meaning that the government now, for instance, if somebody owned a residential holding, government now and was selling it, government now was looking to charge that, even though this asset was not being used for any business purposes. So that proposal seemed to have been dropped by Parliament, little wonder. But the other proposals that seem to have been passed and awaiting presidential assent are exemptions. Again, I think venture capitalists and venture capital funds, as well as private equity funds that are registered in Uganda, will receive an exemption on income, which is obviously whatever in Uganda and in Uganda. And this is important because it follows a trend that has been observed. Government over the years has, by way of tax proposals, there's a trend to show that government has tried to increase or encourage foreign direct investments into the country. It has been through exemptions, through reduction of certain taxes, and we'll see some of those later. But in this case, government is trying to encourage these private equity firms, expand access to capital by local businesses. And I think we'll also see another proposal where government has traditionally interest payments to foreign institutions were exempt, but in this amendment, government seems to have introduced a 2%. So I think looking at these two, private equity is being encouraged, and the tax on financial institutions, interest paid to financial institutions out of Uganda, the government slapping it. Well, it's still low, it's 2%. The going average, I think, has been 15% for other interest payments out of the country. But now government has introduced a 2%. It remains to be seen whether that will be increased in subsequent years. So this disposal of government securities has also received confirmation of exemption of that income. I think what's also interesting was income for manufacturers of electric vehicles, electric batteries, electric charging equipment, or fabricators of the frame and body of electric vehicles. And I think whereas this seems like or most commentators feel that this is aimed at or maybe aimed at some kind of environmental levy or compliance with environmental obligations for the government. Others are looking at it as, is this aimed to target specific projects? Because in Uganda, I think we know the one electric motor vehicle manufacturer is Kira Motors, who has received significant other incentives. But this is one that has been proposed and passed by Parliament. So again, it remains to be seen whether this will be approved, assented to by the President. And then I think for specialized hospitals, again, we know there are two manufacturers. I mean, there are two investors. There's the Aga Khan Hospital and Lubua Hospitals, which have been in the pipeline and whose construction is ongoing. So again, is this specialized hospital incentive meant to further incentivize those two investors, or is it, aimed to attract investment into this sector? Of course, it is known that in Uganda, there is a lot of medical tourism outbound, and what is to be seen now is whether these incentives will attract construction and development in this sector, and maybe increase more inbound medical tourism. There are changes to the definition of branch under the Local Income Tax Act, and really that is to align with Uganda's DT double taxation agreement, as well as the UN model double taxation agreement. The word now has been changed from branch to permanent establishment, and really adopted the language in the UN model double taxation agreement, which expands that definition. I think one of the things that has already been subject of judicial interpretation is whether the permanent establishment and the non-resident person that owns it are separate, and whether they must transact at arm's length. I think the Ugandan courts have already pronounced themselves on that in terms of VAT and withholding tax on imported services by a PE. Where they have interpreted, where the courts have stated that the PE is required to withhold both VAT and withholding tax on importation of those services. In terms of source of income, I think they've just expanded the sources, just clarified really. That annuities and payment of insurance premium, if it relates to insurance or insurance risk in Uganda, shall also attract, shall also be looked at, if a non-resident earns these kinds of income in Uganda, they will be treated as income sourced from Uganda and subject to tax. Other developments in other proposals in the income tax amendment were interest paid to non-residential financial institutions. I said traditionally or previously this was exempt, but now this has received or the law has now proposed, or the law has been passed with a 2% taxation on that. So this means that when paying a foreign institution, a foreign financial institution interest, now there is a requirement to withhold a 2% tax. Previously, it was 0%. There are additional transfer pricing compliance requirements. I think previously under the law, taxpayers were only required to maintain records. But now at the time of filing, the law has proposed that you also, if the transaction is controlled, that you're required to submit documentation around the nature of the transaction, the amounts involved, and as well as documentation the transfer pricing method used at the time of filing. So this increases the burden of compliance in that respect, and it will remain to be seen how this is done, noting that there are significant penalties for non-compliance with the transfer pricing requirements under the Act. I think one of the other ones that is similar to the presentation by Mr. Chacha is we have also had an introduction of a withholding tax on commissions paid to payment service providers. So this is twofold. There's a withholding tax on commissions paid as well as an excise duty on withdrawals. So in terms of charging the digital economy, those, and I think this has also been a trend. We have seen, I think in the last 4 or 5 amendments, there has been a charge on either electronic services or these payment service providers, the telecommunication sector agents and banking agents have all been targeted in the changes to the tax laws. VAT, like I said, is very light. I think I'll just mention one which aligns with the changes in the Income Tax Act. The government has increased the scope of exempt supplies to increase, to add for locally manufactured electric vehicles. Again, this is to spur growth, development, attract development in those sectors, in the electric car manufacturing sector. Summary of the proposed changes to excise duty. I think the key ones that caused the most, that it invoked the biggest reaction from taxpayers and the public generally were on cement. I think cement now, the tax has increased to 500 Ugandan shillings per 50 kgs. The criticism here has been this is really increasing the cost of building materials and will have a huge impact on taxpayers. Then there was a proposal to add tax to kerosene, petrol and diesel, but I think Parliament rejected the increase of tax on kerosene because this affects the everyday Ugandan, and the tax on petrol and diesel was maintained. I think the question here is whether this is a deliberate move by the government to try and comply with its requirements, climate change and environmental obligations to try and reduce the use of fossil fuels, or whether this, the petroleum products is just a soft target, where government knows that they can increase revenues from. The other stamp duty, again, they were also light, but again, just to the main one was really to align with the changes in the Income Tax Act as well as the Excise Duty Act, the VAT Act on the exemption of income for private equities and venture capital funds, which are regulated in Uganda. Again, the clarification is that not all PEs that are doing business in Uganda qualify. It is only those which have registered and are regulated by the Capital Markets Authority of Uganda. So they will have exemptions to they'll have exemptions for stamp duty, for their stamp duty transactions. And this is also similar. This is not just for electric car manufacturers. I think government has identified a couple of strategic projects and strategic industries. I think we have in agriculture, commercial agriculture, farming, agro-processing, I think manufacturing, building materials, I think targeting the tiling industry, where government has provided similar exemptions, of course, with requirements, their conditions to comply. Some of the ones that I can highlight very quickly, you have to use at least 70% source raw materials from Uganda, and you have your wage bill and employees must as well constitute 70% of the total wage bill, total number of employees, and a few others, really promoting local content, but at the same time spurring development in those sectors. I'll also touch on recent tax decisions. There've been a number, but I'll just highlight some which I think have impacted the landscape of tax practice in Uganda. We have, I think, on the issue of access to the Tax Appeals Tribunal. The Tax Appeals Tribunal imposes a 30%. 30%, there's a requirement to pay 30% to access that. And previously, you could also go to the High Court with a dispute. You could choose, a taxpayer could choose whether to go to the Tax Appeals Tribunal or the High Court. But now the court has come out, the Supreme Court of Uganda came out and confirmed that in matters involving tax, the Tax Appeals Tribunal has jurisdiction, and the jurisdiction of the High Court to that extent is limited. So under the Constitution, under the Constitution, the High Court has unlimited original jurisdiction, but it says at the beginning, I think, of that clause, it says subject to other provisions of the Constitution. And that same Constitution is the one that gave our Parliament, the Parliament of Uganda, a right to establish tax appeals tribunals to adjudicate tax matters. So to that extent, the court has held that yes, the High Court has unlimited jurisdiction, but when it comes to tax matters, that jurisdiction is limited. So what that means now in Uganda is that for anyone that has a tax matter, it has to be instituted before the Tax Appeals Tribunal. And since this decision, what this has shown is that the number of cases at the Tax Appeals Tribunal has increased, and we'll see how this has also impacted the jurisprudence on, okay, if I have to pay, do I have to pay 30% in all cases? So I think initially this matter had been settled by the Supreme Court in 2010, where it held that 30% is mandatory, and it is not contrary to the right of a fair hearing, which is non-derogable. But in 2020, the Constitutional Court distinguished the earlier case of UPMAC and said that yes, 30% is payable. It is in its own right mandatory, but that is if you're contesting the quantum of taxes assessed. So if I'm challenging whether I'm liable to pay the tax or not, or if I'm challenging a private ruling or some other administrative decision by the tax authority, then I do not have to pay the 30%. And there was a lot, I think, of discourse in the tax fraternity. Tax practitioners were confused. Okay, do we follow the Supreme Court decision because we know it has binding impact on all lower courts, or now do we follow UPMAC, which is a constitutional court? Constitutional court is the court of appeal, but you know, it sits as a constitutional court when deciding matters of constitutional interpretation. So subsequent to FuelX coming out in 2020, in 2021, the Tax Appeals Tribunal decided a number of cases, but I'll just highlight Better Place Limited versus URA, in which the tax tribunal confirmed that the two cases are not inconsistent. That is the UPMAC, which said that 15% is mandatory, and the FuelX case, which said that you can pay, you don't have to pay the 30% if you're not challenging the quantum of taxes. So it said that really FuelX just clarified the previous case of UPMAC, and if you're challenging a legal interpretation, and you are not at all challenging the tax, challenging the tax quantum or an assessment, then the 30% does not apply. If you are challenging both the tax assessed as well as you have an aspect that is challenging legal interpretation, then the 30% applies. So that settled that matter. The next question was, do I have to pay the entire 30% in one lump sum, before I access the tax appeals tribunal, or can I pay it in installments? Because some of these tax assessments are huge. In the case of Century Bottling Company Limited, Coca-Cola, it happened during, I think, the early days of COVID. The company was going through, just as many other companies, I think their sales had dropped to about 50%. And they had so many challenges. So they applied, and they had been given an assessment of about 58 billion. So they applied to the tax, they applied to the Commissioner General of URA, who declined to give them a payment plan to pay the 30% in installments. So what happened is that they applied for a review to the Commissioner General. They applied for a review to the Tax Appeals Tribunal, which stated that, yes, the discretion under Section 28 of the Tax Appeals Tribunal is given to the Commissioner General to determine whether to pay installments or not. But where it is not exercised judiciously, then a taxpayer can apply to the Tax Appeals Tribunal for review of that decision. And I think in this case, the authority allowed Coca-Cola to pay the 30% in 4 installments. Other cases on this, I think there's Tata versus URA and several other cases, but the essence or the gist now is that, yes, if you have, if you cannot pay the 30%, then the procedure is applied to the Commissioner General, request for a payment plan. And if that payment plan is either denied or, it's not satisfactory, then there may be a window to have that reviewed by the Tax Appeals Tribunal, and a payment plan allowed for the taxpayer. The last one I think I'll touch on, in the interest of time, is the accrual of, I call this interest, but it's really penal tax during dispute resolution. I think this is an old case which started in 2004. But was finally determined by the Supreme Court in 2023, last year, in September, where the question was, during dispute resolution, does penal tax freeze? I think our VAT Act provides under Section 65(3) that once a tax is due, not paid on the due date, then there's a penal tax of 2% compounded. So the question was, if I've paid my 30%, does that not freeze accrual of interest on the 70% because I am challenging the 70%? Now the Supreme Court came out and said, I think originally the Court of Appeal had said that 30% contravenes or is inconsistent with the right to a fair hearing, requiring the payment of penalties during dispute resolution contravenes the right to a fair hearing. But the Supreme Court last year came out and said that penal tax is applicable until payment of the outstanding tax in full. Harsh as it may sound, this is the law, and the language of suspension of penal tax that the Constitutional Court had relied on to say that penal tax is suspended is not included, is not supported by any law. And so the current situation in Uganda is that the 30%, is that interest accrues during dispute resolution, which now really buttresses the principle that I think was established in an old South African case of Metcash, that you have to pay now and argue later. So this is advice that has to be given to clients. If you're fighting URA, you must first pay the taxes to avoid accumulation of taxes. Of course, there are other provisions which were introduced since this case. In this case, I think the tax that was supposed to be paid was about only 600 million, but by the time the matter had been heard by the Supreme Court, because of penal tax, it had increased to about 1.5 billion. Right now, under the current law, we have what is called interest and penal tax capping. So if this were to happen, if this case had been decided, the most that the interest and penal tax would have been the same as the principal tax, which is 600 million. but nonetheless, a client should not have to pay that additional amount if they can help it. So the mantra now is really to pay now and argue later. I think I'll end with this case, which is also important. I think what we have seen now, what we have seen in Uganda, in terms of tax practice, is URA under the tax. URA is a tax collector, but under the laws, it has broad powers. It has broad powers to access premises, records, data from a taxpayer, sometimes with notice and even without notice. And in this case of ABC Capital and 30 others versus Attorney General, what the banks were challenging was this right. URA had written to all banks requiring them to provide personal information of their clients. So it initially asked for account details, and then later details of all account holders, and then later asked for even more information, personal information such as the names, emails, IDs, total credits, total debits, and all that. So what the Constitutional Court held was that, well, it said that Section 41 and 42 are not unconstitutional in and of themselves, but to the extent that URA issued this request in a blanket format without probable cause and without an investigation, those sections contravened or inconsistent with the right of privacy, which is guaranteed under the Constitution. So yes, URA can still have access to your bank records, but only if there is some kind of investigation or they have probable cause to show that there's a tax which is owing that you didn't pay, or there's tax evasion going on. That is the only way in which they can have access to this. And this really, I think, was a win for the taxpayers and was very welcome. Although I think there's need for further pushback on really curtailing the rights which were given to URA under Section 41 and 42 of the TPC. We'll wait to see, or we'll see how this develops. There are other tax cases, but I'll not go into them. I think Mr. Chacha talked about accrual versus payment. In Uganda, I think the courts have decided that in the case of ATC and several other cases, where they have held that withholding tax accrues, I mean, the obligation to withhold tax accrues not on payment, but on, for instance, if it is interest on capitalization, as long as the obligation to pay arises, then the obligation to withhold also arises. So I think in the ATC case, it was about capitalizing interest, and URA said the moment you capitalize, I mean, the Tax Appeals Tribunal stated, and I think the High Court also agreed with them, that the moment you have capitalized that interest, then the obligation to withhold accrues, despite that you have not yet paid the interest. And I think what's interesting is the courts have looked at or what has informed all these decisions by the court on accrual versus payment is in the financial statements of all these taxpayers. After the obligation accrued, they had taken the benefit of the deduction. So the courts are saying, if you have taken the benefit of the deduction, then you have to pay the tax. You cannot have your cake. You cannot eat your cake and have it too. And so that's how that matter has developed in Uganda. I think I'll also just mention very quickly, IFRIS. I think if you have been following developments in Uganda, there's been trader strikes on enforcement of IFRIS. IFRIS is electronic fiscal reporting and invoicing solution, which was introduced by URA to really assist in the collection and administration of VAT. It was initially challenged by, I think it was, there were designated taxpayers who were required to comply with it. And I think it started with the supermarkets. And so the early cases challenging this were supermarket cases. And I think the challenge was there was a huge penalty of about 6 million shillings, which URA had interpreted as 6 million per transaction. So if you didn't, the way URA was trying to enforce it was if you hadn't paid, if you hadn't used an electronic invoice on a transaction, however small it was, even if it was equivalent of $2 or $3, you would have to pay a penalty of 6. But I think the courts now have come out and settled this and said this penalty is per tax period, which is 1 month. And I think moving on to URA increased the scope of designated payers that are supposed to comply with IFRIS, including the traders. And I think because we all know Uganda is, when it comes to access to data, access to, these sophisticated fiscal devices and understanding them, there was a bit of a mismatch. So the traders claim that, requiring them to buy these machines, requiring them to have an accountant, a printer, to have all these receipts printed out is unfair. So the law has changed, it is still there. You have to comply with IFRIS, and non-compliance attracts penalties. I think there are a number of other cases, but in the interest of time, I will leave it at that. I think another one which is important for the ESC is, I think, testimony motors versus URA. I think now a number of cases which have really confirmed the sanctity of the transaction value method. I think has been trying I'll use the case of testimony motors. I think importation of cars, the law states that before you use any other method, the first method should be the transaction value method, which is rely on the documents that have been provided by the taxpayer, rely on their commercial invoice, the documents that they are presented to you. But seems that because of a lot of fraud and under declaration by importers of vehicles, they decided to come up with a schedule, which schedule, irrespective of how much you bought a car, and the actual value of the car, are estimated and relied on its own values. So I think testimony motors challenged that. It's an old case, but the decision, I think, also came out recently, where the courts required URA to use the transaction value method, and only when they could not estimate what the value of the taxes is when they can use the ultimate amount. So predicting future trends, I think from my perspective, it's really, we know that the budget is high. We know that the domestic revenue targets are going to be very high. So we can expect that the government of Uganda through URA will double down on enforcement measures. So we expect, the reaction by the traders was just a precursor to what's to come. We expect more pushback from the taxpayers. And I think our role as advisors is to help the taxpayers pushing back on some of those excesses. I'm glad to know that Tanzania has moved to collection of taxes the proper way. I think in Uganda, we're still lagging a little bit behind. We still have cases of arbitrary agency says. We still have cases of contempt of court. I understand, or some clients have indicated that, for instance, in cases of testimony motors, I think there's another case with K files where they're clear code decisions. URA has,
Sophia, if I may.
you know, time.
Yes, if I may.
Okay. Yeah.
Because
so I think
of the essence of time, you could make your conclusion.
Okay.
On,
so I'll stop.
Yes.
Yeah. I think to Tanzania, we also have dispute resolution is picking up. We now have the ADR rules, which came out also last year. Yeah, I think I'll just sum it up by saying that I think as tax advisors, lawyers, we have a very huge role in checking the excesses of the government, URA, whether it's as a result of tax amendment or enforcement measures. If these are not right, the role that is the role of us, the lawyers. And I think lawyers in Uganda are doing a very good job in pushing back on that, as we've seen from the Supreme Court, the cases that are coming out of the Supreme Court and the tax appeals tribunal. I'll leave it at that for now. Thank you for having me.
Thank you, Sophia. Just a reminder to the members, if you do have a question, you can key it in the Q&A box. Moving on, our next panelist is Dieudonné, who is a partner in ENS Africa, specializing in tax and corporate commercial practice. He's recognized by the market for his tax specialization on various international and domestic tax law matters. He holds an LLB and LLM in business law at the top of his graduating classes from the University of Rwanda, and has an advanced diploma in international taxation from the Chartered Institute of Taxation of the United Kingdom. He's admitted as an advocate of the Supreme Court of Rwanda and other courts, and is a member of the Rwanda Bar Association, a member of the East African Law Society, and currently sits at the Tax Law Committee. He's also a member of the International Bar Association. He's also an affiliate of the Chartered Institute of Taxation, United Kingdom, and a member of the Tax Committee of the Institute Certified Public Accountants in Rwanda. Dieudonné is consistently ranked among the best lawyers in the Rwandan market by chambers and by partners. He publishes articles, makes media interventions, and speaks at various forums on various corporate and tax topics. He's also a visiting lecturer on tax and corporate practices within the Institute of Legal Practice and Development. So, Mr. Dieudonné, you can take us through our today's topic and probably give us an insight on the tax compliance in Rwanda. Thank you.
Oh, thank you very much, Lillian, for the introduction. I know this topic can be a bit tricky because when you're discussing trends, it's not easy to determine where to start from. But for my presentation, I'll focus on whatever happened in the year 2023 and how it's impacting the business community in Rwanda. And I will not be sharing a presentation here, but I have some aide-memoire to use here. So, starting with legal trends. So we've had an overhaul of Rwandan tax system over the last year. So we got the amendment of the Income Tax Act, where the CIT rate was reduced from standard CIT rate was reduced from 30% to 28%. And of course, that came, as a result of a benchmarking exercise where it was realized that, we are not faring well in terms of our corporate income tax rate, and it was decided that it should be reduced to 28%, something that was welcomed by the business community. We also, in September, got a new VAT law, and this also introduced a lot of changes. And one of the changes introduced by the new VAT law is a provision on taxation of digital supplies or supplies made online. But of course, this being like an abstract provision, the law is not clear how this is going to work, because as you can imagine, if you're dealing with non-resident suppliers, who are not even registered for tax purposes in Rwanda, we are expecting to see the means of Finance and Economic Planning, issuing guidelines in form of a ministerial order on how VAT on digital online supplies is going to be corrected. So the new VAT law also introduced a change which has been trying to be implemented by the RRA in practice, but was not contained in the law, where now the VAT refund is restricted in a manner that if you've dealt with the taxpayer and that taxpayer you dealt with have not limited the VAT you pay them, you're not going to be allowed a refund unless and until that VAT is limited to the revenue authority. So of course, this is one of the change that was not welcomed by the tax community, because the point they're making that they don't have control over their suppliers and they shouldn't be penalized for non-compliance by their suppliers. And very interestingly, much as this was practiced before this change in law, so Rwandan courts had said no to that. They were clear that a taxpayer should not be denied input VAT or VAT refund because the other taxpayer did not comply. But now that it's in the law, so the court's options are very limited. But maybe as an update, there is a constitutional case that's been brought before the Supreme Court for the Supreme Court to invalidate this provision on the ground that it violates the right to property and equal treatment by the law. But maybe we'll have to discuss this when the Supreme Court will have handed down its ruling on this. The new VAT law also extended the list of exempted goods and zero-rated, exempt and zero-rated goods. And just to give some of the examples, one of the goods and that have been included on the list of exempted and zero-rated, goods, as the case may be, is electric vehicles and hybrid vehicles, where the law provides that, for imported electric vehicles and hybrid vehicles, they are going to be exempted from VAT, and those assembled locally will be zero-rated. And this is in line with the government policy for promoting, the environment protection, particularly, the green economy. And that's indeed one of the interesting changes. There's also exemption from VAT on processed maize flour and rice, and this came as a way of dealing with the soaring prices or maybe the cost of living. Then another change introduced in the VAT relates to the importation of services, because unlike many ESC countries, actually, if not all ESC economies, where VAT paid, VAT on imported services, is allowed as input VAT by the importer, and therefore, there is no VAT payable by the person importing a service. In Rwanda, VAT on imported service cannot be allowed if the service imported are not local available. Otherwise, if the services imported are local available, the taxpayer importing the service is not going to be allowed input VAT. So there have been kind of an outcry from taxpayers on this, especially that, the test of availability of the service locally was more of an issue. And the new VAT law now introduced, a process where a taxpayer would get the approval from the Minister of Finance on the absence of the similar or same service on the local market, so that if that service is imported, they will be automatically entitled to input VAT tax credit. So another change that was introduced in this specific sphere of VAT is also awarding final consumers requesting electronic invoices and paying VAT, where a consumer will be getting 10% of the VAT paid as a way of incentivizing them to pay VAT and contribute to the treasury. And maybe while still on the VAT, because that's why I mentioned the introduction of the taxation of digital supplies. So unlike Kenya, I think even Uganda, we don't have digital service tax. Neither do we have the significant economic business threshold. So basically, on the income tax side, there is no clear position on how the highly digitalized businesses, especially foreign businesses, are taxed in Rwanda. So there have been also developments in the real estate, particularly property taxes. Now Rwanda has a new tax on the sale of movable property, which is 2% and 2.5% for non-registered for persons not registered for income tax, and persons register for income tax respectively. So basically, if you register for CIT and sell disposal of an immovable property, you would pay 2%. But of course, that tax paid is allowed as a deductible expense at the time of computing your CIT. But if you're not registered for tax purposes and you dispose of your immovable property, will be liable to 2% of the value. But the first 5 million of the proceeds from the sale is exempted from that specific type of tax. There is also a current ongoing voluntary disclosure scheme where the Ministry of Finance has made an announcement inviting all taxpayers, including those maybe who think they may have not made a proper declaration of their taxable income and the other taxes, except customs or import duties, to disclose that by June 22nd, so that, in which case they don't have to pay the principal and won't be subjected to penalties. Then something which is of course relevant to privacy and taxpayers' rights. So Rwanda has also enacted our own automatic exchange of information for tax purposes, which is of course in line with the recently undertaken, international obligations, where Rwanda, has not recently signed the OECD Convention on Mutual Assistance in administrative assistance in tax matters. So, and part of this. What this law provides for is basically to allow RRA to have access to financial accounts information, and this were basically maybe the right to privacy of the taxpayers may come into question. But of course, as you can imagine, the right to privacy is not without restriction, even constitutionally. All human rights are subject to restriction provided for by the law, and which are aimed at public interest and welfare of the community at large. So there have been also the enactment of a new law on excise duties, and this introduced excise duty on a number of products which were not previously subject to excise duty, and those are electronic cigarette, chocolates, and sweets and chewing gums. So we did not used to have excess duty on those types of products, but now the new excise duty law introduces taxes on those specific products. Now, then I think those are quite briefly, the updates I can share in terms of legislative changes in year 2023. In terms of the change that maybe we may expect as a result of the new budget, I don't think there will be any new tax to be introduced as part of the new budget, except that we expect the Minister of Finance to apply for stay of application of the EC Customs Management Act on certain products, especially electric vehicles and hybrid vehicles, because the stay of application has been allowed, is ending in June this year, and it's likely that looking at the policy considerations here, it's likely that the government of Rwanda is going to extend the stay of application of ESC common external tariff still on the imported electronic vehicles and batteries and their spare parts. Now, in terms of case law developments, still I'll focus on those cases that have been decided in this year. There are two interesting cases which I think are worth sharing. The first case was recently, started from, of course, lower courts, but was recently confirmed by the Court of Appeal, which in that specific case was the final instance, was related to the taxation of business profits under the double tax treaty between Rwanda and Mauritius, and this basically related to a Mauritian resident who supplied goods to Rwandan public institutions, and when making payment to that suppliers, those Rwandan public institutions withheld 15% from the payments made to the Mauritian resident. And the matter was taken to go to with the argument that given that the Mauritian entity did not have a permanent establishment in Rwanda, then Rwanda did not have the right to tax its business profit. The Commercial High Court the Commercial Court, the Commercial High Court ruled in favor of the taxpayer, and even the Court of Appeal confirmed the same decision. But what is interesting in this case, I mean, the fact that business profit, especially from the supply of goods, can be taxed in the source state only if there is a permanent establishment, is a no-brainer. I don't think we need to spend, I need to spend much time on that. Also, sometimes you've seen tax administration in various countries misbehaving in that regard, particularly on service fees, in the absence of article on taxation of technical and management service fees. So the court has to answer two important questions. The first question that was asked by the court is the interaction between mutual agreement procedure and, domestic remedies, because the Revenue Authority was arguing that given that this is a matter, arising from the DTA between two countries, the taxpayer ought to have resorted to the mutual agreement procedure before taking the matter to court. But the court said that looking at the wording of the relevant provision of the DTA, MAP is an option, not an obligation, and therefore nothing could prevent a taxpayer from taking the matter to court directly regardless of the MAP under the relevant DTA. The second question that was also asked by the court in that specific case is whether entitlement to treaty benefit is necessarily, subject to the requirement that the taxpayer has paid tax in its country of residence, because the Revenue Authority was like, look, the purpose of DTA is to eliminate double taxation, unless and until the taxpayer proves, the applicant proves that they have paid tax in Mauritius, the Revenue Authority was not in a position to refund the tax withheld. And the court was, look, this is not the business of the tax administration, so long as the detail is clear that the taxation of business profit is exclusive to the country of source, and to the state of residence of the taxpayer, unless you prove that there is a permanent establishment, then there is no need to investigate whether tax was paid or is going to be paid in the country of residence. So I think that's a very interesting case, which I think may be relevant even to other markets, especially that it is about a double tax treaty. Another interesting case, which was decided by the Supreme Court in December last year, so relates to the taxation of goods that, of packed supply of goods or mixed supply of goods, where one good has a different VAT regime from another. Let's say, for instance, you're supplying equipment, but also and the supply of such equipment is exempted from VAT, but you are also supplying installation services which are subject to VAT, and those services are accessory to the supply of equipment. Basically, the accessory supply could not have happened had there not been the main supply. So in this specific case, the Supreme Court held that, in such case, the VAT regime to apply is the VAT regime applicable to the supply that is part of the core or main undertaking of the taxpayer. So the value does not matter, so long as, what you've supplied is part of your core undertaking or your business. Any other accessory supply you're making must follow the VAT regime of that other main supply. And this specific case, the case was about a distributor of products of one of the largest breweries in this country. But in addition to the supply of those goods, the distributor could also provide transportation services of those goods. And under the income and under the VAT Act, transportation services by licensed transporters is exempted from VAT. So, but in this specific case, the court made it clear that even if transportation services are exempted from VAT, they are only exempted for people or persons undertaking transportation services as part of their core or main business. And that specific case, since the main business or core business of the taxpayer was the distribution of those goods or products, then the transportation services have had to follow the regime of those goods that were distributed. And this is a very interesting case because it's likely to have implication even on other sector, and much as in this specific case, it worked in favor of the revenue authority because it was pushing for taxation of transportation services by distributors. It may also be the other way around. Take an example of supplier of solar water heaters, which are exempted from VAT, but they have to provide the installation services which are supposed to be subject to VAT. And as you can imagine, in that case, if you were to follow the ruling of the Supreme Court, so those installation services would also have to be exempted. Same for electric vehicles and after-sale services. So this case is really supposed to have, implication on, suppliers of taxpayers making mixed or combined supplies where one good is the main supplier and the other is accessory. So I think that's one case, but I think it also makes sense to make like a general comment on the dispute resolution landscape in Rwanda. So as has been mentioned for my colleagues in the other markets, revenue authorities are trying to settle tax dispute through amicable settlement, which is also another layer within the dispute resolution framework after audit objection before the Commissioner General. So that's also the case in Rwanda, and the Revenue Authority has been trying to that. But it's also not, to bring to the audience's attention that, there is an increase, in scrutinizing the transaction between, related parties, which means, transfer pricing, audits that are really increasing in Rwanda, and accordingly, we're also likely to have a lot of transfer pricing disputes for obvious reasons, because, of course, those are the usual suspect and, present a risk of eroding, the base of source countries and shifting profits to low tax jurisdiction. So I think that's quite, briefly what I had to share as trends and updates, in Rwanda, at least from January 2023 to date. Thank you.
Thank you very much, Dieudonné, for that very insightful update on the trends in Rwanda. And to all in attendance, that marks the end of the presentations by the panelists. So before we move to the plenary, I think one of the key things that has come out from all the presentations is that the partner states that have been represented during this session, we've seen a common denominator in that the governments are trying to increase the revenues by way of getting taxes and places where they would ordinarily not have looked into as potential loopholes to get more revenue. But I think what has emerged from this discussion is that a balance has to be put by the governments to ensure that while on one hand you're trying to increase your revenues and reduce reliance on foreign debt and other debt, then they also have to ensure that the taxes that are being introduced are also going in line with their current and future goals, which in this case we've seen in the region, there's been a push to have the green economy, as well as to promote foreign direct investment. So in this case, I think as the legislature in each of these countries goes back to deliberate on the bills that are currently undergoing public participation, I believe that these are certain fundamental principles that needs to be taken into account to ensure that while on one hand we are trying to increase, for instance, indirect taxes, we don't end up getting a leakage from the direct taxes side. So I think this is something that we should potentially flag as we do our public participation responses to ensure that we continue to retain the bird at hand rather than to retain none. So thank you once again to the presenters. And there are a couple of questions that had been raised in the chat box. I'll quickly go to them and then have, I think, each of you answer maybe one question. So the first question is from Mr. Hakil Gonja. And this goes to Chacha. So Chacha, is it deterrent enough to impose a higher rate of taxation at the expense of environmental pollution caused by imposition, or I think this is the imposition of advanced and or aged vehicles. We have a question to Ellie, where you asked whether you could provide more details on how the Kenyan Finance Bill affects taxpayer rights and shifts power in favor of the Kenya Revenue Authority when handling disputes and collections. I think those are the only two questions in the chat box. Perhaps I can include two more for the other two panelists. To Sophia, you mentioned you took us into great lengths to explain how the 30% tax as a prerequisite to access the tribunal has evolved over the years with the jurisprudence from the Supreme Court and the Court of Appeal. But you mentioned that if you will be exempted from paying the 30% as per the Constitutional Court's ruling, if you're able to show that you're only challenging the legal interpretation of that particular decision you're objecting to. But don't you think that in making a legal argument, you, by extent, also have to make an argument with respect to the final assessment that was done? Because in this, on one hand, if we are saying, for instance, that a client should not have been required to pay withholding tax based on this legal provision, then it effectively means that the assessment, which has been confirmed through the objection decision, is therefore null and void. And then lastly, I think to Dieudonné, we had a change that has been introduced under the Kenyan Finance Bill, which is in respect of advanced pricing arrangements with the revenue authorities, where basically parties can be able to enter into these advanced pricing arrangements with the commissioner, which would be enforced for about 5 years and can be voided by the commissioner if the commissioner can be able to establish some representation by the taxpayer when coming up with this agreement. So we understand that these arrangements are currently in place in Tanzania, Uganda, and Rwanda. So maybe you could give us some more insights on how the practicalities of this and whether it's being taken up by many companies that have quite a lot of dealings with their foreign subsidiaries or the holding companies. So I think we can start with those questions, and then feel free to ask any other burning questions in the chat, and then we can take another round of questions. Thank you.
Well, so I think, Ikoha, thank you. I think I should start because the first question was addressed to I, hopefully. That's fine?
Yes, that is in order.
All right. So the colleague is asking if it's deterrent enough to impose higher taxes at the expense actually of environmental protection. I think that is the summary of the question, right? Yeah. Well, so theoretically, actually, and which is the very theoretical and policy rationale of these environmental taxes, is that they operate on internalizing the externalities, or rather on a person bearing the burden, or rather shouldering the burden on the harm that this person is causing to the society or to the community. Okay, so if a person pollutes the environment, example, by using a motor vehicle, which is the case here, so there is noise pollution. The ozone layer also gets depleted because of the gases. Okay, and ultimately the impacts are being borne by the community as the whole, by innocent people. So there are people who have to buy ACs, example, okay, because it's heating. There are people who have to shift their consumption patterns because of this act of a person who has actually caused this harm. Now, the policies, because you have caused this harm and actually you have impacted other people, then you have to contribute. You have to contribute to, you have to pay a portion of the harm that you have caused. So most jurisdiction and example areas consider that approach by imposing significant tax as part of compensating, as part of internalizing the externalities which actually the pollution would causes. So most of example, the EU country have significant taxes on environmental taxes. And the aim is basically twofold. That's why it's high in many countries. The aim is twofold. One is to disincentivize you from using that product, which is actually climate sensitive. And second, the aim is to actually to make you to shift your consumption pattern. So if the motor vehicle purchase of a motor vehicle of fuel, which uses fossil fuel, is expensive, but not only purchasing it, if using it on daily basis is also expensive because the carbon taxes paid are higher, then this person will have two options. One, not to buy a motor vehicle and use public transport, okay? Or second, to buy a motor vehicle which is natural gas. So by doing so, we are creating two main things which are very important, which you say it's a double deviance. One, we're getting revenue, okay? But second, also, we are transitioning people to adopt climate neutral technologies, but also to have the consumption pattern which is clean, okay? And ultimately achieving the net zero emission, which we are targeting by 2050. So it's fine. And other jurisdictions have the calculations that if you use this product, it produces. If you use, example, you drink water from a plastic, the production of that plastic actually did release certain banned, let's say, certain gases, which will, so you have to pay higher to purchase the same, or rather pay lesser for a very clean technology, and ultimately save that other person who is struggling because of your consumption behaviors. Yeah. So it's balanced, and it's the computational part of the extent is actually on people of numbers who work it out, but they aim to achieve that one, to assist people to transition, but also to shift their consumption pattern to clean, and second, to disincentivize people from using this one as the ultimate benefit of the society, and ultimately achieving two, climate friendly, okay, and second, revenue generation. So I think that's how it is, and I think I've addressed the colleagues' the colleagues' question. Thank you.
Thank you. Maybe we can proceed to Ellie.
Thank you, Ikoha. Looking at this question, this is one key area of concern that is coming out of the proposals in the finance bill of 2024. And even as you are aware, was a key challenge that came out of the previous finance bill in 2023. Basically, some changes are creating a regulatory mismatch and are eroding the rights of taxpayers when it comes to dealing with assessments by the Revenue Authority or trying to challenge assessments and decisions by the Revenue Authority. Basically, what's happening, the changes are more and more not allowing taxpayers and the Revenue Authority to be on the same footing in whenever there is a dispute between them. I'll give some examples that are proposed in this finance bill. For example, when responding to a tax assessment, the taxpayer usually has 30 days to challenge the assessment. In this time period, the taxpayer is required to, collect all the necessary documents, explanations, etc., and submit the challenge to the tax authority. The tax authority currently has 60 days to respond. What has increasingly been happening is due to the volume and number of tax disputes that arise, the KRA is increasingly facing challenges in meeting the 60-day timeline. To me, it looks like a capacity issue. In my view, KRA should be moving more towards increasing its resources and capacity in terms of the officers handling this objection decision. But the government looks like it wants to move in the opposite direction, which is to give the Revenue Authority 90 days to respond instead of 60 days. So you can see the kind of mismatch we're talking about, where me as a taxpayer, I am under high pressure to collect documentation and submit a challenge in 30 days. The Revenue Authority is given a broader timeline of up to 90 days to respond. There is a similar issue arising in challenging assessments, where they are now proposing to give the Revenue Authority 14 days. Within 14 days of you challenging an assessment, they can respond to say you have not given sufficient documentation. And in such a case, should you fail to give sufficient documentation within the set timeline of 14 days, your challenge is automatically disallowed and you have no further recourse as a taxpayer to challenge the assessment. Again, this is is stacking the process in favor of the Revenue Authority. What we are likely to see is the Revenue Authority making requests for a lot of documents, which sometimes might not, strictly speaking, be necessary for the resolution of the dispute. But while the taxpayer is struggling up and down to collect the documents, submit them, they might be caught up by 14 days and lose their right of appeal. We briefly spoke about the issue of data privacy and these wide sweeping powers that the commissioner is obtaining to get documents, records from taxpayers, and even other third parties from your bankers, etc. When on the taxpayer side, of course, there are obviously no similar sweeping powers, but in addition, they are facing challenges like the one we discussed of they are not getting reasons for tax assessments and decisions. So KRA has all these many sources of documentation, records, information, while the taxpayer, on the other hand, does not have enough information about the issue that is in dispute between the parties. So these are the kinds of changes that increasingly are coming up. Just important to note, last year there was a proposal to introduce a similar provision like the one Sophia has discussed about in Uganda, where there was to be a requirement to pay up to 50% of the tax due before being permitted to appeal from certain tax decisions, which again would have tilted the playing field in favor of the government. This was shot down for exactly the reason that it was discriminatory, it was unfair, it was creating an unfair mismatch in favor of the taxpayer, in favor of the Revenue Authority vis-a-vis the taxpayer. So with this in mind, we are keen to see whether similar Sena minds will prevail and we will get to have amendments that actually maintain the balance and the equality of arms, as opposed to stacking the dispute resolution process in favor of the Revenue Authority at the expense of the taxpayer. Thank you.
Thank you, Eli. I can see the Dieudonné is open. Your mic is on.
Yes. So thanks, Mahindi. So I think the issue of APAs in Rwanda, advance pricing agreements. So I think it may be good to share some background. So we used to have the advance pricing arrangement agreement under the 2005 Income Tax Act, which was repealed in 2018. And in the Income Tax Act of 2018, we did not see the APAs provided therein. And then when we got a new Income Tax Act last year in 2022, the APAs were introduced. So, but in terms of practical experience in relation to that, I would say that there is no experience as such for the reasons I'm going to explain. So during the period between 2005 and 2018, when we had that in the law, so we did not have like a robust transfer pricing enforcement for obvious reasons, one being capacity, but we didn't even have like detailed transfer pricing rules as what we have now. So, and that's why we didn't see multinationals picking interest into engaging in the APA's arrangement with the Revenue Authority. Later on, the fact that there were not even a lot of TP audits. But now that the APA was introduced by the 2022 Income Tax Act, and indeed, we are getting a more robust transfer pricing enforcement, even the TP laws that are quite detailed. So I can certainly see the multinationals operating in Rwanda exploring this option, at least for certain purposes, because at least with an APA, you're sure that the TP method agreed with the Revenue Authority, the markups, so whatever margins that are agreed with the Revenue Authority are not going to be questioned down the line unless maybe there's change in circumstances, or maybe there have been the presentation. And maybe while I'm still on this, I thought maybe the change in the Income Tax Act at all to be discussed here. Let me also share something, which is very interesting and should be brought to the attention of the audience. Part of the changes introduced, by the Income Tax Act in 2022, somehow related to TP, is the introduction of a general anti-avoidance provision. For the first time, we've never had that. And this is something maybe, the people doing business in Rwanda need to be aware of, because now the Revenue Authority has, the power to look into your transaction, and sometimes recharacterize it or maybe reject it, altogether, if indeed it appears that one of its main purpose was to avoid taxes. Thank you.
Thank you for that. And finally, so we have Sophia.
Thank you. Again, I think the courts, the tax appeals tribunal specifically and the High Court have clarified on under which circumstances that 30% is not supposed to be paid. So again, legal interpretation really focuses on if a party is successful, ideally in a legal interpretation, it means that the entire assessment would be vacated. So you're never going to have a situation where you're going to discuss, or the court is going to look at whether the quantum of the assessment was excessive, whether it should be reduced or maintained. Here, the taxpayer is strictly asking the court to look at their facts and the law and confirm that the tax which has been assessed does not apply to them. Either they are exempt by a tax law, or they have a waiver, or there's a tax ruling, or some other reason as to why they should not have been assessed for that tax in the first place. So in terms of interpretation, how it has been defined by the jurisprudence or by the courts is really that there's never going to be an issue of discussing the quantum of what has been assessed. It's really on whether that taxpayer has a right, whether that taxpayer was qualified to be assessed for that tax in the first place. So once that question is, if that is a question that you're taking to TAT or any other tribunal or court for that matter, then there is no requirement to pay 30%. I hope that clarifies it.
Yes, with that, it clarifies it very well, Sophia. Thanks for that clarification. So I think in the interest of time, I'll hand over the session back to Brenna. But before then, I would like to thank the panelists for taking time this afternoon to take us through these robust changes in each of your respective jurisdictions, as well as for the members for asking very insightful questions to each of the panelists and the co-moderators. So back to you, Brenna.
Thank you. This was a very informative session. A big thanks to our incredible moderators. We appreciate so much our dear panelists who blocked their schedules to have time to dedicate to this session. Thank you, participants, for always tuning in, for participating, for making our webinar interactive and lively. I would like to take this moment to invite each one of you to our legal and legislative drafting workshop taking place in Arusha, Tanzania from 4th to 7th June 2024. We are just 12 days away, and I'm happy Registration is still open. Please, if you're interested, reach out to us or register online to book your seats. Today's session is recorded and will be uploaded on our YouTube channel, on ELS YouTube channel. So feel free to visit and watch the recording for further information. And again, to stay informed, please follow us on social media, on Facebook, X, or on LinkedIn, even on Instagram, to make sure that you have the updates. Have a blessed evening or afternoon, depending on where you are. We look forward to hosting you again on Thursday for our next webinar on data privacy and data protection. Until then, bye-bye.